Broadcast is now starting. All attendees are in listen-only mode.
Okay, welcome to another tax-linked webinar. Today we're looking at data protection in Europe and beyond. We're actually taking a closer look at the GDPR, which kicks in May of 2018, and I know it's of great interest to all of our members. So let me get some admin issues out of the way first before I ask our panelists to introduce themselves. On the dashboard, on the GoToWebinar control panel, you have the opportunity to actually submit questions. So if you have any questions that you're interested in asking our panelists, please make sure to post them there, and I'll make sure to incorporate them into the discussion. Also, Sam from IAPP has sent us a couple handouts. If you go to the handouts section on the control panel, you'll be able to download those. So please feel free to do that. With that said, let me get started. I will be moderating the event. I'm just Matteo, the content manager for TaxLinked. So without further ado, let me ask Nick, please, can you introduce yourself?
Yes, of course. Good afternoon, ladies and gentlemen. My name is Dr. Nick Skrekas. I'm a lawyer and economist, and I'm also an expert trainer for the European Institute for Management of Finance. Please feel free to call me Nick, and I welcome all your questions.
Excellent, thank you, Nick. Sam, please.
Hi, everybody. Good morning from Portsmouth, New Hampshire in the United States. I am the content director for the International Association of Privacy Professionals, and we are a membership organization with 33,000 members now all over the world. As you might imagine, we're growing very fast because of people responding to the General Data Protection Regulation. And the purpose we serve is to empower the privacy professional, those people who are doing data protection and privacy inside of organizations. And so it's my job to build resources that help you do your job better. So happy to be here.
Excellent. And finally, Tomaso Falchetta, please, a few words about your role and your job.
Hello, everyone, and thanks for inviting me. I'm Tomaso Falchetta. I'm the Advocacy and Policy team lead here at Privacy International. For those who don't know, Privacy International is a non-governmental organization. We are an international organization based in London, and we work to campaign for stronger protection of privacy and data protection. Thank you.
Excellent. Thank you for the introductions, gentlemen. Let's just get started with our Q&A session. So to get us started, I guess the general question on GDPR. What are the main principles of the GDPR? Nick, you want to take a first crack at that one?
Sure. There are actually 6 principles outlined in Article 5 of the regulation, but there is also 1/7 principle which is implied. And the first one that I think of is lawfulness, fairness, and transparency. Personal data must be processed lawfully, fairly, and transparently. The second one is a purpose limitation. Personal data can only be collected for specified, explicit, and legitimate purposes. The third one is data minimization. Personal data must be adequate, relevant, and limited to what is necessary for processing. Less is more. Accuracy. Personal data must be accurate and kept up to date. The fifth one, storage limitation. Personal data must be kept in a form such that the data can be identified only as long as necessary for processing. And the sixth, integrity and confidentiality. Personal data must be processed in a manner that ensures its security. And the seventh one, which is implied in Article 5, is that the data controller is responsible for demonstrating this, and they must secure the same assurances from any external data processes. Now, having mentioned those principles, I'd also like to say that these principles in Article 5 of the regulation are really at the heart of the regulation. And just note that infringement of these principles, any of them, carries with it the hefty fine of the hire of euro 20 million or 4% of annual turnover.
Okay, thank you, Nick. Sam, do you have anything to add to the question on principles?
Yeah, I guess the only thing I would add is, these principles for people who are in the data protection community aren't new. This is something that goes back to the OECD and, even some of the work that was being done in the 60s in the United States. Really what's impressive or important or different here is that we now have them ensconced in an EU-wide law. So, those who have been sort of running accountable organizations all along, none of these principles should really be brand new or a surprise. But for organizations that are coming to privacy new, the fact that these are legal obligations now might pose some operational difficulty. If you haven't been doing these things, you're definitely going to have to change the way you do business a little bit.
Excellent. Tomaso, anything to add to Sam or Nick's comments?
I guess it was alluded to start with. I think one principle that for us is very important because underpins then also some of the rights of data subject is this principle of accountability, which, as it was mentioned, is kind of implied, but pretty much there in GDPR, and that is a relatively new concept and very important for us.
Yeah, and just to build on that, you heard me say accountable as well. This accountability concept is really becoming a global concept. And so, this is not a EU-only phenomenon. You'll see this in Asia, privacy law now. Even the Federal Trade Commission here in the United States is starting to use the word accountable a lot. So, it's a sort of nebulous concept that a lot of our members ask a lot of questions about, but it's really at the core of the GDPR.
Excellent. Okay, thanks for that clarification, Sam. Okay, now in terms of what does personal data actually constitute? Sam, do you want to get us started with that? I mean, when we talk about personal data, what is it?
I really wish I had a definitive answer here, but it's basically new and different almost every day in that it's any data that can positively identify an individual, basically. I think 5 years ago, if you had asked me, is a static IP address personal information, I probably would have said no. And then the Court of Justice of the European Union says that it is. And so we sort of have a new definition. As we get into the digital age, location data. So one piece of physical location, is that personal information? Well, now we have researchers that prove that with just 4 location data points, you can positively identify somebody with about 95% confidence. So I would encourage people to think of it very broadly. Any data that you can use to figure out who a specific person is, that's personal data. And the law is not going to give you a list of all the data that you need to keep track of because the GDPR is purposely vague to account for changes in technology. So there's no big giant spreadsheet that anybody can point to that says, here, these are all the types of personal data. You really need to think deeply about the data that you're collecting, and in isolation, could somebody use that data to figure out who somebody is? If the answer to that is yes, it's personal data.
Excellent. Tomaso, anything to add to Sam's definition of personal data? His perspective on it?
I actually just echo what Sam mentioned. I think it's very important for data controllers to realize that the breadth of personal data is kind of is pretty broad, and especially with the development of new technologies and the way from a particular data set you can identify an individual or a combination of data sets will allow to identify an individual. It makes the concept of personal data a sort of dynamic concept, I would say. And the court, definitely the Court of Justice of the European Union helps to identify some of the borderline cases, let's say. Similarly, data protection authorities, including when they meet together as part of the Working Party 29, which collects the data protection authorities within the EU also provide guidance on concept of personal data and its scope.
Okay, thank you, Tomaso. Nick, anything to add on personal data, the definition?
Something that I would like to introduce as a concept early on in the discussion is that I think what the European Union is trying to do here is to pass a de facto global standard for privacy, because it doesn't just apply to EU companies, it applies to non-EU companies who are looking to trade or do business with EU residents. So what we're looking at here is quite a larger global effort to get everyone up to speed.
Okay, that actually provides a good segue to the next question, which is, who does the GDPR actually affect? I mean, who is going to come under scrutiny in terms of this law? Nick, do you want to get us started with that?
Sure. Look, every company in Europe is covered by the regulation, simply just by having some privacy material and personal data in their HR department. But it extends much further than just the European Exclusive Economic Area, which is the EU plus Liechtenstein, Norway, and Iceland. It also covers companies outside of the EU who are looking to sell goods or products to EU residents, not necessarily citizens, residents, and it also applies to companies outside of the European Union who are simply monitoring residents of the EU. So there is extraterritorial effect here.
Okay, Sam, anything to add to that?
Yeah, so we actually have done quite a bit of research on who is affected by the GDPR. We asked our 33,000 members. Now, obviously, there's a little bit of a bias because if you've taken the time to be a member of the IAPP, you obviously are collecting personal data and you have some understanding of privacy law. Otherwise, you wouldn't bother paying us your $250 a year. But we asked them, do you think that you are covered by the GDPR? And 88% of them said yes. And more than half of our members are in the United States. So, basically, if you're doing business even remotely globally, if you want to sell even one item to someone who lives in the EU, if you have any employees in the EU, you should consider yourself covered by the GDPR. And what we tell our members is, as Nick said, it is sort of establishing a global standard for privacy and data protection across the globe. And that's not something that people are hiding from. What you're seeing are governments in Asia, governments in Latin America, governments in Africa, essentially taking the GDPR and cutting and pasting it into their own law. If you go look at Ghana's new data protection law, it's basically the GDPR, and every place it says the EU, they put in the word Ghana. This is not something that is an outlier. This is something that other governments are sort of glomming onto because they want to do trade with the EU. It's the second or third biggest trading partner in the world, depending on who you are. We sort of encourage our members, whether you think maybe there's some loophole that means that you aren't covered by the GDPR, you might as well pay attention to it and be in compliance with it because it's going to help you do business everywhere anyway.
Excellent. Just as a quick follow-up question to that one, because we received the question earlier today in which our member was talking about the legislation which, in her perspective, was drafted having in mind large companies. And, her question was mainly how will it affect actually micro or small companies specifically. You broached that a little bit.
Well, so
expand on how it will affect micro or small companies.
Yeah, I mean, a law is only as good as its oversight and regulation, right? So, do I think that the French data protection regulator, the CNIL, is going to be examining the data protection practices of the local patisserie on the corner as soon as the GDPR goes live? No, I don't. I think they'll probably focus on, you know, larger companies that have larger stores of personal information. But you know, if you go look at the enforcement actions of, say, the Information Commissioner's Office in the UK, the vast majority of their enforcement actions are against pretty small operators. It's usually for spam texting or, you know, inappropriate direct marketing. You know, if you're a small business and you are sending out emails to people that haven't given you consent to receive those emails, you know, the e-privacy regulation is going to trigger, or the GDPR is going to trigger, and it really just takes a complaint. If someone says, hey, this small business is violating the GDPR, and the local regulator has bandwidth, you can believe they'll follow up on it. So it absolutely covers anyone who's handling data. And if you look at the sort of history of the way that the law was created, at one point in the draft, there was a carve out for companies with 200 or fewer employees, and they expressly got rid of that. It doesn't have anything to do with how big you are. It's solely based on whether you're processing personal data or not.
Okay, excellent. Tomaso, do you want to add to that?
Ameliorating provisions depending on the size of companies. And the one that comes top of my head is the necessity to keep records. If your company has less than 250 employees, you don't need to keep records as intensively as what you need to do if you have more than 250 employees. But that's about it. The rest affects the same small company as it would a big company. You have to comply with the regulation, and without doing so, you risk not only lawsuits but administrative fines that are massive.
Okay, Tomaso, do you want anything to add?
Well, I wanted to add one small point, but also I had sort of a question that, if you don't mind, I can ask the other panelists, and particularly maybe Sam. So the only point to add is that this issue of the size of the company, as has been mentioned, it's not that relevant in the context of GDPR. But one of the reasons is also that you have the reality of some small companies, like certain type of startup companies, that actually process a lot of, actually their business model is about processing a lot of personal data, including sensitive data. So this idea of having this, you know, dichotomy between big companies and a small one is one that one need to kind of look a little bit more closely to see the kind of business they do. The question I had, and I don't know whether am I allowed to kind of ask a question to?
Yeah, sure.
Sorry,
sure, Tomaso.
Because I totally agree with the fact that the GDPR is sort of setting a standard that obviously other governments are looking at, and we have noticed that as well. And we have a partner organization in Latin America and some in Asia that are telling us that some of the data protection reform taking place in those countries is spurred by the GDPR, or at least partly. But my question is, to what extent companies themselves maybe see the opportunity or maybe the fact that they have to comply with GDPR when they process data of European, to what extent that is used to kind of bring up the standards across the company, irrespective of which area, which part of the world they actually process data and of whom they process data.
Yeah, we actually have some interesting data on that, and you know, I try not to read too much narrative into data because, you know, we can all sort of tell our own story. But, you know, we asked in our most recent piece of research that comes out actually at our conference next week in Brussels, the Data Protection Congress, we asked our members, when do you think that you'll be in compliance with the GDPR? It's a very difficult law, and, you know, it takes some companies, you know, years to sort of figure it out. They only had about an 18-month ramp up. And so about 23% said they would not be compliant on the day it comes into force in May of 2018. And then we split it by US and EU respondents. And the US companies are more confident in being compliant than the EU companies are. And you know, the narrative that I put onto that is the US companies know that they need to be in compliance with the GDPR in order to open up that EU market. The US market is a very different privacy landscape. You have different style of regulation, you have a sectoral approach. It depends on the type of data you're handling. But if you want to do business in the EU, you need to have a world-class privacy operation. Otherwise, you're going to face barriers. You know, you see what's happening with WhatsApp, with Google. You know, the regulators have their eye on Amazon Valley, not Amazon Valley, Silicon Valley companies. And you know, it's about trade as much as it is about compliance. You know, these US companies, they see it as a marketing opportunity. They want to come into Europe and say, hey, we've embraced the GDPR, we believe in data protection, it's core to what we do, come and buy our products, come and use our services. And I think that's true whether they're trying to access the Asian market or the Latin American market or whatever market it is. They don't want regulation to be a barrier. And so I think in some ways in the EU, they've already lived under the directive. You know, data protection is a human right in the EU. It's a sort of a different approach. And I think the EU companies are sort of just waking up now in a way and thinking, oh, wow, the GDPR actually has new obligations that I didn't quite understand. I really need to do some operational things that take a while. I might not be in compliance when it comes into force. Whereas the US companies were tracking this a little closer that wanted to come into the EU, and they were a little bit more ready for it potentially. So I think that's an answer to your question. I think a lot of companies are seeing this as an opportunity to access markets.
Thanks.
Excellent. Nick, any comments on Tomaso's question?
Yes, look, I would agree that it is an excellent opportunity to win markets and also to avoid reputational damage. It's not just about avoiding fines. It's a lot more than that. And I think it's also important to note that EU companies have not been on the cutting edge of developments. They're only now starting to wake up slowly to the needs of the regulation. And when I do consulting for GDPR, I always tell people you need to be doing 3 things a couple of months before May. And that is, you need to do a data analysis, you need to do a gap analysis, and you need to do a legal analysis as well. And those 3 steps are going to take you about 2 months. You're not going to get it done in the week before the regulation comes into effect.
Okay, actually that again provides a good segue to the next question, which is, you know, what responsibilities will company have under this new regulation? Nick, you want to get us started with that one? Overall, what responsibilities do these companies have to follow?
Sure. Well, look, it really depends on whether you're a controller or just a processor. If you're a controller, you have a lot more obligations. You need to be taking operational and technical measures to make sure that the data that you have is safe. You also need to respect the regulation in the sense that you must have a legitimate interest in the kind of data that you're looking at. You need to have confidentiality, non-disclosure agreements with all your staff. And more than that, all staff should not have access to the personal data. It should be on a need-to-know basis. And more than that, as part of the regulation, they have obligations as a company, whether you're a processor or whether you're a controller, to report any data breaches within 72 hours of you finding out that they occurred to the supervisory authority. And also, if they provide a high risk to the rights and liabilities of the personal data subjects, you need to communicate with each data subject as well.
Okay. Tomaso, anything to add to what Nick has said in terms of responsibilities for the companies?
Well, I mean, I think the main ones have been flagged. I guess the other one that is quite important is the requirement for data protection by default and by design, which is very much linked to the idea, for example, of one of the principles that was mentioned earlier of data minimization. So basically, you cannot when you think about processing personal data, you need to put in place a way that basically you process the least that is necessary, and so this kind of default data protection minimization is very important. The second point, and I agree that controller and processors are still kind of obviously different, but the GDPR does address the responsibility of processors as well, which is something quite new compared, for example, to the European directive on data protection, which put most of the burden only to the controllers.
Okay, Sam, anything to add on responsibilities?
Yeah, you know, we can come up with a big list of responsibilities, actually. You know, I think the biggest responsibility, I think, is to understand the data that you hold and the consent that's attached to it. And I think that is at the core of the difficulty of compliance with the GDPR, in that, you know, as Nick was saying, you know, give yourself 2 months to understand your data. If you are a large company, give yourself maybe a year to understand your data. Where does it live? Because it's everything. It's the data on individual hard drives. It's the data on thumb drives. It's the data on servers. It's the data that you hold in cloud accounts. It's the data on your Dropbox. It's the data. That data is very slippery. It's the data in your email. It's the data on your bring your own device, you know, phones and laptops and iPads, and you know, it is not a simple thing to track that data, and it's not a simple thing to track the consent that's attached to that data. So, you know, someone signs up for you know, sweepstakes that you're running, you know, win a new car and give us your email address and a little bit of personal data. What are you allowed to do with that? How long are you allowed to do something with that? What, you know, how long, when are you supposed to destroy it? Many companies don't have any policies around these things at all, and the GDPR demands that you do. And you know, some of these things are just things that people don't think about. When storage started to get cheap, everybody, you know, many IT departments just decided to store everything forever. Why would you delete anything? You know, I've got terabytes of storage, might as well keep it around. Nowadays, that creates a major risk for your company. You should understand why you have that data, and if you don't need it, if you're not using it, we certainly encourage people to delete it, because it presents a regulatory risk. And I also thank you for Matteo putting out that report link to people. I think the other responsibility you have is, you know, gets back to accountability. You have a responsibility to demonstrate that you are in compliance with the GDPR. And you know, that's baked into the law, is that if anybody comes asking, if the CNIL comes asking, if Leipzig-Schweigstang in Germany comes asking, you need to prove that you're in compliance. How are you going to do that? And so what I put out there for people is our annual privacy governance report. It's something that we've been doing for 3 years. And what it does is set a baseline for what a privacy program actually looks like. How many staff should you have working on privacy? How much money should you be spending on privacy? Where should your privacy program be located? Who should the privacy leader report to? You know, I think we're going to get into the data protection officer later, so I won't talk directly about that. But you do have an obligation to prove that you are taking data protection seriously and that you have a plan for compliance. It's not just a matter. It's not just a matter of like breaking the law, right? The GDPR isn't just waiting around to see if you rob the bank or not. The GDPR expects everybody to be in compliance on demand, and you never know who might come knocking. It really just comes down to an individual complaint, or you know, God forbid you have a data breach and you don't have a plan for notification. That's going to be a giant red flag that you are not in compliance.
Right. Thank you, Sam. And actually, you mentioned the data protection officer, and that was my next question. So let's move on. What is a data protection officer, and which companies need to appoint a DPO? Tomaso, you want to get us started with that one?
Well, yeah, I mean, I can try. The data protection officer is basically the person that is responsible to ensure, basically, that the company has data protection is compliant with the GDPR, and so that's a very important role. The GDPR, suggests some of the kind of requirements of the data protection officers, including in terms of being qualified to actually know the standards. In terms of which companies need to have a DPO, I think that's a little bit less clear, at least in the GDPR. I'll go back, I guess, to the point I made earlier, that a lot may well depend on the type of data and the amount of data that you are actually processing. So it's not kind of sort of a black and white sort of type of decision. It really requires some understanding of the kind of data that you hold and whether or not it is at the level of risk that really requires to have a DPO.
Sam, anything to add?
I can talk literally for hours about the data protection officer, and I have done so in the past, so I'll try to keep my remarks brief. This is at the core of what our members are doing. And the first point I would make is that the data protection officer is a very specific role in the GDPR. Many companies use sort of data protection officer as a little bit of a catch-all term for their privacy leader, or somebody on the privacy team. But now, once that GDPR comes into force, the data protection officer is a legally prescribed role with very specific duties. Another of the links that I shared in the downloads, the top 10 operational impacts of the GDPR, there's a whole chapter on the data protection officer, so I'm not going to go into every duty that they have. But I agree that it's not clear who has to have a mandatory DPO or not. But I think it's wrapped up in two core questions. The first question is data processing core to what you do as a business, right? If you are doing data processing as the way you make money, you definitely need to have a mandatory DPO. If you are a travel service and you need to track location of people in order to offer them the right car deal because they're going to be in Paris and they might want to rent a car, you should have a DPO. If you are, even if you're putting out an app, say, the point that Tomaso made earlier, you might be a two-person company that made an app that you sell in the App Store. If that app relies on location data or access to contacts or access to your camera or anything like that is personal data, you absolutely need to have a DPO. That is your business, and they will expect you to have somebody who's a data protection officer. It might be your founder, it might be your chief financial officer, but it needs to be somebody. And then the second question is, do you handle particularly sensitive data? Even a little bit, right? So in Article 9 of the GDPR, which I would encourage people to read, it's very concise and it's very important. There are certain types of data that are particularly sensitive in the GDPR, things like health data, sexual orientation data, whether you're in a labor union data, those data that are particularly tied into your ability to exercise your rights and freedom. So even if your core business is not processing data, but you're storing that data even a little bit, you really need to have a data protection officer, because the GDPR, they will bring the harshest fines if you are not processing that sensitive data correctly. And so, there's also guidance on our website. If you go to IAPP.org, we have a ton of resources. And if you look up the guidance that the Article 29 Working Party has put out, and they are the group of all the data protection authorities in Europe, their guidance says that they would expect you to err on the side of having a DPO. They are not going to be particularly thrilled with the conversation of legalese about why you think you are. They're not going to want to have a conversation with you where you are, doing semantic tricks and trying to dance around the fact that you don't need a DPO. That's not something they want to engage in, and that's going to make them sort of hyper aware that maybe you are not sort of convincing in your compliance. They tell you to sort of err on the side of the DPO, but, and this comes with a caveat, is they also say if you give someone that title, whether you are required to have one or not, the requirements of the law come down onto that data protection officer. So once you give someone that title, they are legally obligated to do a number of things. So think carefully about who you make the DPO as well.
Okay, Nick, anything to add on the DPO discussion to what Sam and Tomaso have said? Can you hear me, Nick? Nick? I don't think he. Let me get in touch with him via the chat. Let's move on to the next question then. Since we're talking about compliance and we're talking about, I guess, penalties and fines, what happens if a company does not comply to the GDPR? Nick, can you hear me now? Or Tomaso, let's go with you, Tomaso. Let me see what's going on with Nick. Tomaso.
Well, I think it was mentioned that if there is no compliance, there is a risk of quite high fines, something that is much raise the risk of non-compliance very strongly. I wanted to make a particular point with regards to compliance, though, which is something that we are very much advocating for, and that is in relation to the possibility of a collective form of action. Maybe we'll talk a bit more later, but basically there is one thing which is about the right of data subjects to bring a complaint before a data protection authority when they think that their data has been processed unlawfully or inside the standards of the GDPR. But one important provisions of the GDPR is Article 80, Paragraph 2, which gives member states the discretion to give qualified privacy, data protection type of non-profit organization the possibility to bring sort of collective complaints, they don't like it in Europe to be called class actions, but basically, I guess in the US that would be sort of the kind of terminology it may be used. And this is something which is very important because as maybe we will discuss a bit later, often the harm to data subject, including whether or not there has been a violation of the right, is hidden and or is very complex to actually prove. And it's through organization that can kind of present a case on behalf of a number of individuals, but also sort of in their own accord, that this kind of gap between compliance and non-compliance can be breached, and we have seen that some countries already in Europe allow for this kind of form of collective redress, such as Germany. In the UK, where I'm based, currently the government has put forward a new data protection bill, which does not, unfortunately, in the proposal of the government include this collective complaint mechanism. But we are at the early stages of the parliamentary debate around the bill, so we are hoping that to see that also in the UK legislation.
Thank you, Tomaso. Sam, anything to add on compliance and penalties, fines, etc., or anything that Tomaso said?
I think a lot of people are obviously focused on the fines. It really changes the powers that data protection authorities have in the EU. Very few of them have administrative fining powers, and certainly not to the level that the GDPR allows them. But I don't think it's true that your average data protection authority is going to go to fining powers right out of the gate. They recently put out guidance on administrative fines, and they explicitly say that if you are able to demonstrate your attempts at accountability, if you're able to demonstrate that you do have a data protection officer, that you do have an accountability framework, that you do have policies in place, they do make allowances for human error. So, just because you had a data breach doesn't mean you're going to get fined 4% of your global turnover. But if you have a data breach and they come and investigate and you don't have policies and you haven't done training and you don't have a data protection officer, then absolutely you should expect fines. But if you've done everything right and you've made an honest effort and you can say, oh, hey, we're in compliance with ISO 27001 cybersecurity, and we have a big robust privacy staff, and we have annual privacy training with intermittent checkups, that's going to go a long way to mitigating that enforcement. And so there is absolutely an incentive from the data protection authorities to demonstrate that in compliance and build it into your program.
Excellent. Nick, anything you want to add? Can you hear us now?
Just on the issue of the data protection officer, there are 3 conditions that are spelled out in the regulation. If you're a public authority, you need a DPO. If you do regular and systemic monitoring of data subjects on a large scale, say for example, more than 5,000 data subjects in 12 months, you absolutely need a DPO. If you have more than 250 employees, it's not absolutely mandatory, but it's highly likely that you will need a DPO. And also, if you process large quantities of special categories of data, like criminal convictions, health, sex life, trade union membership, etc. If you process large quantities of these special data categories, you absolutely need a DPO. There is, however, some positive news. A group can hire only 1 DPO to handle all the data protection issues at both headquarters and subsidiaries. Furthermore, it's also possible to contract out the DPO function to an expert or a law firm.
Okay, Nick. Let's move on, as we're running out of time here. Not running out of time, but we still got a good 20 minutes. And we have another 6 questions to go. Under the GDPR, how does a company obtain consent? Nick, you want to get us started with that?
Yeah. Consent is a bit of a magic bullet in terms of the regulation, or a silver bullet, I should say. And consent must be freely given, it must be specific, informed, and unambiguous. Silence, pre-tick boxes, or inactivity aren't permitted as consent. And consent has to be consent to all the processing activities, all of them, not just some of them. Consent is not strictly necessary in cases where it's leading up to a contract or in order to protect the rights of the data subject. But beyond these exemptions, you absolutely need to ensure that you have a data subject's consent for processing any of their data. And the consent document must be laid out in simple terms and conditions. It's got to be clear, concise, and not unnecessarily disruptive. Please leave out the legalese.
Okay. Anything to add, Sam or Tomaso, on consent?
So that's the other document that I did put up there for distribution, which is a real, if I do say so myself, good examination of what the GDPR says about consent. But it also has user interface design suggestions from a user interface designer, right? So you really do need to get into questions of, you know, if you pre-populate the yes box and then just have people say okay, is that unambiguous consent? Is that informed consent? Probably not, right? You want them to take an active role in picking the yes versus the no. And so there's a lot of examples like that in the white paper, and I encourage people to take a look at it. And the other thing I would say is, you know, I think you really need to think hard in your organization about what unambiguous versus explicit means. Especially if you're collecting those special categories of data, you need explicit consent to process it. And the GDPR does make a distinction between unambiguous and explicit. And I think, you know, as a writer, this is one of the, you know, great brain teasers of legislation is how they distinguish between unambiguous and explicit in 28 different languages in the EU. I can barely tell the difference in English as a native speaker. I have no idea what the equivalent words are in all the other 28 different languages that people are doing businesses in the EU. I find it very difficult to explain. We make an attempt in the paper that I think works, but you know, I don't know what the French or German or whatever distinctions are, and this is something that, you know, you should err on the side of caution here. The GDPR, if you're relying on consent for your processing, and the Article 29 Working Party makes this point, you put yourself in a little bit of legal danger because you need to justify that the consent is explicit, is unambiguous. It's probably a better idea not to rely on consent most of the time. It should probably be a better idea to rely on the fulfillment of a contract, or, you know, one of the other derogations for processing that are a little bit more explicit. And so, you know, I would, you know, a lot of people see, exactly as Nick said, consent as this, you know, silver bullet for processing whatever you want. You know, it really needs to be specific. It's a one-time thing. You can't gather consent to process as much as you want. It's just explicitly not allowed. So, you know, if consent is what you think you're going to be using, I would say really pay your lawyers well.
And more than that,
Tomaso?
I would just like to add that with consent, bear in mind that consent is able to be withdrawn. And the data subject has to be informed of his rights to be able to withdraw consent.
Okay. Tomaso, anything to add on the subject of?
I was going to mention the withdrawal aspect, because it's very, very important. The only other thing to add, I guess, is the fact that the controller needs to actually demonstrate that it has obtained the consent. So that puts quite a burden on the controller to actually demonstrate that the consent, or with all the conditions that Sam just mentioned, had been obtained. That's again is part of, I guess, falls under the concept of accountability principle that underpins GDPR.
Okay. Okay, let's shift gears here a bit, and let's talk about how does the GDPR apply to company employees? What are, I guess this goes back to the responsibility question. Tomaso, you want to get us started with that one?
No, I'd rather have Sam starting or Nick, and I can add.
Okay. Sam, you want to go for it? Go for it.
Sure, I'd be happy to take a swing. It applies to your employees in the same way that it applies to any data subject, really. The GDPR doesn't make a distinction between, you know, a customer's personal data and an employee's personal data. If it's personal data, you have an obligation to protect it in the way the GDPR outlines. This is a particularly foreign concept in the United States, where you know, we very much think of as employees as part of the company and customers sort of as not. And I've had to explain this to many of our members: is you don't get any bonus points for having them work for you. In fact, it's a little bit harder to do data protection on your employee data because they really can't provide consent because of the power structure that's involved in the employment contract. The Article 29 Working Party has been very clear about this. Employees can't really consent in a real way because there's a penalty if they don't consent, which might be them getting fired or them not getting a promotion or that sort of thing. It really should be contracted, and your employees should have a very good understanding of how their data is going to be processed, and it should be even like workplace surveillance issues. We just had a great Court of Justice decision on that as well. You have to provide notice that you're doing it. You have to be able to demonstrate the legal reason why you're doing it, the legitimate interest, and it is not okay for you to ask employees to consent to that because they don't have a real power to consent. So I would say that, Nick said it right on the outset, if you have employees, you're covered in the EU, you're covered by the GDPR, and you have a real obligation to protect their data just like anybody else's.
Excellent. Nick, anything to add to what Sam has said?
Yeah, I would just like to add that personal data must be classified as confidential, even inside the organization. And the only people that should have access are the ones who need access, not everyone. And employees must be bound by confidentiality agreements. They should only process data in accordance with instructions from the controller, and they should not send data overseas without a contractual binding corporate rules agreement. So organizations have to process data in a manner that ensures appropriate security against unlawful processing, against accidental loss, destruction, or damage. So it does apply to company employees very much so.
Excellent. Okay, let's move on. We have about 10-15 minutes left. Let's talk now about the individual rights under the GDPR. What rights will individuals have under GDPR? I think Tomaso, you can handle this one.
Sure. I mean, the GDPR contains 8, we say, sort of rights for data subject. I don't necessarily need to go one by one, but basically the key elements here is that the data subject is put in a position to know what data is processed about him or herself, and that the data subject is also in a stronger position to actually control the processing of that data, which includes in terms of the right to seek for rectification of the data, seek for erasure of the data, and the right to seek even limitation or restriction of the processing of the data, or objecting to processing in certain cases. Another right that has come out, and as I know that has kind of created a lot of discussion because it's a relatively new right, is this right to data portability, and I think some mentioned the work of the Working Party 29 of the National Data Protection Authority, just recently come out with some sort of guidelines on what that right means. But basically, again, the idea is to give, the underlying idea is to give data subject control over their data, including the possibility to request their personal data in order, for example, to take it somewhere else, to move from one provider to another, and how technically that is going to work out. It's something that, as I said, the Working Party 29 has tried to clarify. But the underlying rationale of this set of rights is basically putting the data subject in having more control on what happened to their personal data.
Sam, anything to add on individual rights?
No, I think Tomas really covered it. I would just encourage people to almost think of the data that they hold, the personal data hold, as almost a physical object. The person who is giving you that personal data, they're giving you a ball, they're giving you, a coin, whatever it is, and they can take it back. You are just a caretaker of it. And they can tell you what they want you to do with it. They can tell you to destroy it. They can tell you to make it into a different shape. They can tell you to give it to somebody else. Just because it's in a digital format doesn't sort of change the nature of ownership. The GDPR really brings into law this idea that people own their data, and if you are processing it, you're just a caretaker. You're the bank, and you have obligations to care for it.
Okay, Nick, anything to add on individuals? Individual rights, I guess, under the GDPR that hasn't been said? No, okay. We have about 7 more minutes. Let's not just take a general question on data protection. Like, in your opinion, I mean, what are some of the other trending topics in data protection? I mean, what interests you these days in data protection? Just to, for our community to get a sense of what they should be looking out for, etc. Sam, you want to get started with that one?
Sure. I think one of the biggest trends that we're following is data localization law. Whether you think the GDPR is a data localization law or not, many countries, Russia specifically, Turkey, China, Thailand, they are passing laws that do not allow for personal data of their citizens, their people, their natural born persons, they have various ways of saying it, can travel outside of their borders. And data is by its nature very slippery. You don't necessarily know where that person you're interacting with over the internet is. And you really need to know now. If you're collecting the data of someone in Russia, that data needs to stay in Russia. If you're collecting the data of someone in China, there are pretty arcane rules now because of China's new cybersecurity law that sort of dictate that what the nature of that data is and why you have permission for it to travel outside of China's borders. And we don't see this as a trend that's going away. We think there will be more data localization. It kind of depends on your view. Some people call them privacy laws, some people call them surveillance laws, some people say it's a way to repress freedom of expression. I'm not going to get into the political nature of it. I'm just going to say operationally, you're opening yourself up to risk if you don't know where that data is coming from, because you may have obligations to store it in a certain place. And not a lot of companies think about that. They're using so many cloud providers and Amazon Web Services or whatever it happens to be. Do you know where that server is, and do you know where that data sort of physically rests? If you don't, you really should, because you may have some regulatory risk you don't know about.
Right, excellent. Tomaso, any current trends that you're seeing now as part of Privacy International, or any comment on what Sam has said about data localization?
No, I mean, on data localization, yes, we also noticed this trend, and we are concerned, particularly when data localization is imposed in countries that then can use other means to actually access that data, and that actually brings me to the broader issue, which is the interrelationship between data protection and privacy, particularly in the context of surveillance. So you have on one side, we mentioned some of the principles under the data protection GDPR, including not to retain your data for longer than is necessary. And then on the other side, you have a push by governments, particularly including European governments, to actually asking or demanding or requiring companies to retain the data in order to be able to access it later on in case they need it for reasons of law enforcement or national security. That's just for one example where there is this tension. Another one which I don't think everyone knows, the debate around the Microsoft Ireland case, and again it's a question of to what extent a company is put in a position where it has to comply on one side to a request by, let's say in this case, the US authorities to hand over data, but at the same time has obligations under Irish data protection law, which basically say European data protection law, to transfer data to third countries only in certain specific conditions. So that is something that we have to grapple with in the context of our work related to surveillance. It's the overlap and sometimes the conflicts between data protection principles and laws and the demands of access or the demands of surveillance by states.
Okay, excellent. Nick, any current trends that have caught your attention, or any comment on what has been said by Sam and Tomaso?
I would just like to add, in terms of the rights, they have been broadened significantly under the regulation compared to the directive. And one right I'm not sure that we mentioned is the right to be forgotten, erasure. You, as the data subject, have the right to ask the controller to delete your data. There is also data portability, and there is also one more right, which is interesting, which is to not be subject to a decision based solely on automated processing. So AI or algorithms can't make a definitive decision. There has to be some overview of the physical human being. Now, more than that, I think some of the trending topics that are coming up is things like blockchain. We're all familiar with blockchain. It was created in order for parties to bypass centralized systems in a decentralized and more secure way. But the regulation doesn't apply generally to blockchain because it's unclear if the controller, if there is a controller, and who that entity is. More than that, under the GDPR, data subjects are also granted a number of rights which can be in tension with blockchain's immutable characteristics. Most notably, the right to be forgotten, which I mentioned just a few seconds ago. And regulators have to consider how blockchain databases could permit the alteration or removal of data of the data subjects if there is a justifiable request. So look out for activity from the European Data Protection Board once it's up and running on issues like blockchain.
Thank you, Nick. Okay, I think that brings us kind of to the tail end of our webinar. Let me ask you for some final remarks on GDPR or some of the other trending topics that we discussed, and then I'll say goodbye. So, Tomaso, you want to get us started with some concluding remarks on GDPR?
Well, just that, as has been mentioned throughout, it's a complex piece of legislation. We see it, that the states have a range of discretions in the way, although it's a regulation, it has been considered almost an hybrid type of regulation because it gives states a lot of discretion in particular areas, including around how to define public interest, which then links to forms of grounds for processing. So one really need to start looking now how it is implemented and interpreted, and we see that with the Working Party 29, which has been mentioned a couple of times already, we will see it even more as states start to introduce the legislation that is needed to clarify how they take forward those kind of discretionary aspects of the GDPR. So we are very much looking at this space and see how it is going to be applied in practice.
Thank you, Tomaso. Sam, concluding remarks.
Yeah, I'm conscious of our audience here. People in the financial services and tax vertical market. I think probably everybody on this webcon is very used to taking very good care of the data that they're being entrusted with. I don't think you can be successful in financial services or tax preparation if you're sort of just having data breaches all the time and careless with people's information. So I think much of this should be second nature to you. And I would just think about how the GDPR really does apply to the nature of your business. For many companies, if you're a steel manufacturer, I highly doubt that the right to data portability is going to apply to you. In this sort of vertical market, probably data portability will happen. You'll be asked to move records from one tax preparer to another, or from one financial services operator or investment operation to another. How would you go about doing that? How would you make sure that you're transferring all that data in a machine readable way so that someone, maybe even your competitor, could take advantage of the work that you've done to organize the data in a certain way? That's something you should prepare for. And really operationalize those pieces of the GDPR that you think are going to apply to you. The GDPR is by its nature a risk-based piece of legislation. It's not about checking every box. It's about understanding the risks to the people whose data that you hold and mitigating those risks appropriately. So, what are the real risks you have? What's the data that you might lose? What's the data that people might want access to, or to correct, or to delete? Look at that operationally and come up with a plan for how you would actually do those things, rather than worry about the big fine or complying with every single piece of the GDPR. Attack it in a very operational and thoughtful way, and you should be fine. This is not something that should be a Chicken Little, sky is falling situation, especially in this market where you should be taking care of this data anyway.
Excellent. Thank you, Sam. Nick, any final remarks before we say goodbye?
Yes, I would just like to close by saying that in general, we're used to law reforms not being very heavy-handed because there's usually a large outcry. So they tend to be developed incrementally. But this really is not the case with the regulation. It's very strong law regulation coming in one large dose that will affect almost all EU companies and many others around the globe. Don't leave it to the last minute. You need a good few months beforehand to prepare for it. And after this little webinar, I think some of you may have a little bit of background information to actually tackle the regulation itself and read through it closely. It's worth the time and effort, not only to avoid the damaging fines and the crippling fines, but also to avoid damage to your reputation and open up your business to new markets.
Thank you, Nick. So on behalf of TaxLinked, I wanted to thank the three of you for taking the time to actually talk to our members about the GDPR. Thank